have issues to settle, to now try and see that they settle their issues in a very civilized manner, which is to approach the court and listen to what the court has to say. This is the best way to handle our economy. Every day we go on strike, the country loses billions of dollars. And this, at the end of the day, will tell us the economy of the country. It is better for us to settle our issues in a way that will still lead to win-win, and at the end of the day, the continuity of the workplace, either informal or formal, will still be. That is the exit. And in order to realize this, we have put in place in the court, in accordance with the provisions of Section 254C3, an alternative dispute resolution center, which will settle issues emanating from the court. When you file your matters, the judge determines whether it is one of those that will fall within amicable settlement through mediation and conciliation. It will be sent to the center, and within 3 weeks, the center will send either a terms of settlement or send the file back to the court for adjudication. If the parties are able to be reconciled, the terms of settlement will become the judgment of the court. If they are not, the court will be expected to continue with the hearing without any recourse to what transpired at the ADR center. Anything that transpired is without prejudice. This is aimed by the Constitution because the flexibility in law in the labor court ought to follow should not be seen as so strict as it used to be on the bench of the High Court, of which I'm privileged to have been the High Court judge for some years before coming to the National Industrial Court. The two courts are not the same. In the High Court, you must follow the rules strictly. You must follow the rules of evidence. In the National Industrial Court, the law says you may depart from the rules of evidence in the interest of justice. So please don't respond when you say that there are occasions that will tell you, yes, that's what the evidence act is, but in the interest of justice, this is what the court thinks should be done. And I will give you just one example. An employee or a worker. Let's say you're bricklayer on your wages. You ask him to work for you, you pay him 2,000. It's not in writing. Not all labor matters should be in writing. It's a contract that may not be in writing or will be in writing. You agreed to pay him. Mr. A was there when you agreed to pay him. Mr. A told Mr. C, I was there when we agreed to pay this man 2,000 naira. Mr. B could not be seen, but Mr. C could be seen to confirm what Mr. A and Mr. B told him about Mr. A and the contract. Under the Evidence Act is here saying, and it will not be admissible, that since this man has worked for you, he has rendered his services, and somebody has attested to the fact that he had this man in your presence, saying this is how much you are going to pay. The court will dispense with that, saying that it's fair. So otherwise, the court will be an instrument of fraud. The court will be used as an instrument to perpetrate fraud. And don't forget, the 2006 Act of National Industrial Court, which embedded this provision, was there when the Evidence Act 2011 was amended. Now we all know that the provision of the law, if there is a mistake, the Assembly will cure that mistake in amending another law. They were aware of the provision of Section 12.2 of the National Industrial Court when they were amending the relevant provisions of the 2011 and New Evidence Act. They did not tamper. They had no provision to say that notwithstanding Section 12 of this provision. So it's time that they still want that act to remain because it's specialized. So please, gentlemen of the bar, don't let us waste our time by saying, no, we are going on appeal because this is not this, it's not this. I think what we are concerned with is what is the merit of the case. Don't allow technicalities to becloud the court's jurisdiction of hearing the case. I'm persuading this because our colleagues at the back, some of us may be tempted to say no, it can't be or it can be. And the same section 12 says that the court may adopt its own procedure and proceeding as it deems fit. There are occasions that the rules or the act may not cover some grounds, and the court thinks this is the way this matter could be had, and the court will adopt that while it's in consonance with international best practice. So when you come across these minor areas, please don't let us waste more time arguing on this or going on appeal. Legal matters are purely economic matters which should be settled without any waste of time. Once there is no work, the governor cannot perform, the chief judge cannot perform, even your chambers, your employees will not be able to come. Once there is a trade dispute problem which is not resolved, there are occasions that legal matters have been arguing up to court of appeal to break up for 13 years before being sent back, nearly on jurisdiction. A case is before me now. That case, Obuebu and CBN went to Supreme Court. After 23 years, the Supreme Court now sent it back to the National Justice to be heard in Inaugural. If you see the man, it's not his normal self again. After 23 years that he has been dismissed from work. These are some of the mischiefs we are trying to cure by the court official who says that appeal must end at the court of appeal, and that going to court of appeal must deal with the leave of the court of appeal and as may be prescribed an act. But that is another day's argument between you and the judge when issues like that appear before the court. I am quite grateful that this court has been, and I hope cases here may not start more than 12, 18 months before finally settled. We have seen cases within 6 months when they were transferred from the federal high court or state high court. We are able to see what we can do to bring justice to the people in an acceptable manner. Your Excellency, sir, ladies and gentlemen, I recognize the fact that this is not an occasion for long speeches. That, however, I have dwelled into these areas, and to me, I think they are great, and they may cause some understanding between the court and those stakeholders that may be the users of the court. We have everything it takes to make our court very friendly to all that we need to appear before the court. And to our colleagues who are heads of federal prosecutors in Bayelsa State, at times we have a lot of cases coming from you, either the police, the immigration, and all kinds of federal police. We will appreciate if we can make the work of the court less tedious by looking at cases properly before actions are being taken. These days I see that a lot of people are being sacked from different institutions and organizations. It has its own multiplier effect on the larger society. Our court is not concerned with what happens or transpires between the parties before the court or among the parties before the court alone. We are concerned that our pronouncements on the consequential effects of this on the larger society. So when we decide our cases, we are not deciding because, we are in court. We decide because we go in duty to ensure that harmonious and very transparent industrial relations atmosphere prevails in our land. No meaningful foreign investor will come to a land to invest his money if it's not sure that the law, the industrial law, employment law in that country is either certain or ascertainable, definite and consistent, and not undependable. If he is not sure of this, he will not like to invest his hard-earned dollar in our economy. And without foreign investment, the country cannot go the way we have to say to be by year 2020. So for this, we want all hands to be on deck in ensuring that this court succeeds. On my part, as the head of that court, I am open to any one of you to let me know what is happening. But please, I wouldn't like legal practitioners or their counsel to be fond of petitioning, but that does not mean you don't have the right to complain. There are channels of complaining. Try and see the judge with your colleague. Lay your complaint. If the judge is not able to satisfy you, that is why I'm the head of the court. Before petitioning further, have the courtesy of sending your grievances to me. I will send them if it concerns the judge to the judge for his comment, and if it concerns the other party for the other counsel to make a comment. I will now weigh both, and I will see justice is done to the matter. Rather, writing, at the end of the day, your writing may not solve the problem. I think this is a very nice area for us to look into, because as long as the court sits, there may be issues, there may be reasons for you to disagree or agree with the court. Because every day a judge sits in court, with my more than 2 decades experience on this work, every day you deliver judgment, your line of enemies will go up by 1, and your line of friendship will come down by 1, because somebody who wins today will say, Stephen Daniel has come, an upright judge. Tomorrow, if he appears in another case and he loses, don't mind him, he's a corrupt judge. Yesterday, the judge was not a corrupt judge when he won. Today, he didn't win, the judge is a corrupt judge. Please bear with us. Our job in the judiciary as a whole is a very strict and risky job, because we are dedicated on the lives of people. And at times, going by our area of the world, we are not satisfied with God's decisions. If you are not satisfied, if it is in the case you have to appeal, please appeal. If it is the case you have to lay complaint, and we resolve these issues as brothers. Finally, I commend the use of this judicial division to all and sundry. We must imbibe the culture of submitting our disputes and grievances to amicable resolution by the court. And considering that the establishment of this judicial division will contribute in no small measure to the sustenance of varied, friendly, and congenial industrial environment in Bayelsa State. I'm mindful of the prime position of the state as an producing state and the strategic industrial hub is also in Nigeria. This judicial division may be of immense and invaluable benefits to employers and employees alike. Also, the trade unions to welcome suggestions on how to consolidate on the achievements we have achieved so far. Suffice to say that when I came into power as the president of this court 12 years ago, the court had 1 judicial division and half judicial division in Abuja. The court was not regarded strictly to a superior court of appeal. We were operating with members and not judges. Today, I have 24 judicial divisions with edifices that can cope and contend with any of its contemporary anywhere in the world. I have 20 judges, and by the grace of God, we hope to have, if not more than 20 more, or 20 in the year to come. We hope to establish more judicial as the finances of the country improve. I return my personal felicitation to His Excellency, the Governor of our dear state, His Excellency, the Deputy Governor, the Secretary to the State Government, the Chief Judge, the President of the State Customary Court of Appeal, the Attorney General, ably assisted by the Solicitor General and their team, the Chairman of the Bar, both in Bayelsa State and River State, who are here, and all other stakeholders, either from the trade unions, the formal and informal sector of our economy, and the heads of our status, either federal or state, our brothers, judges of various jurisdictions here present. Thank you all for listening and for giving us this audience.
From His Excellency, the Governor of Bayelsa State.
The President, National Industrial Court, Honorable Justice B.A. Adegimo, Officer of the Federal Republic, the President, Customary Court of Appeal, Bayelsa State, Honorable Justice Daniel Aya, judges from the National Industrial Court, and other judges present here, the Secretary to the Government of Bayelsa State, the Honorable Attorney General of Bayelsa State and Commissioner for Justice, the Chief of Staff, Government House, and the Principal Executive Secretary, the Solicitor General, Chairman, Nigerian Bar Association, and other members of the bar, representatives of the security organizations, members of the press, invited guests, distinguished ladies and gentlemen. First, I want to apologize on behalf of His Excellency Right Honorable Henry Dixon, Executive Governor of Bayelsa State, for not being here to personally witness this landmark event in our state. As a lawyer, it would have been more at home here than myself. I just try and fill in for him and read the text that has been left for me to deliver. Today marks a major milestone in the annals of the judicial establishment as it relates to Bayelsa State. Let me first of all express warm felicitation of His Excellency, the Governor, to the President of the National Industrial Court of Nigeria, the Honorable Justices, and staff of the court, the bench, the bar in Bayelsa State, and indeed, the people of the great states, on the occasion of the inauguration of the Yenagoa division of this honorable court. His Excellency the Governor, who himself is a lawyer, would have been quite delighted here, but for very unavoidable national assignments, he has to travel out, and he sent his regards this morning to you. One of the pillars of this restoration administration of His Excellency is need for an independent, viral, and effective justice administration system and guarantee of such access to justice for our people. In this regard, the government was one of the first to make deliberate efforts to preserve independence of the judiciary in the state through the Judicial Free Self-Accounting Bill, which was later passed by the State House of Assembly and signed to law by His Excellency the Governor. It is therefore in pursuit of this vision that the state has consistently supported any process that will ensure access to justice for our people. This includes all that has been done by the government to bring about the establishment of the division of National Industrial Court to Yenagoa. As a government, we are aware that our people, and indeed lawyers representing them, including our lawyers in the Ministry of Justice, have to travel long distances to Calabar, Cross River State, and even Akure in Ondo State to prosecute and defend the interests of the state or their own interests. Being in tune with the yearnings of our people, we are aware that there are those who could not even take their labor cases to National Industrial Courts due to paucity of funds. The implication of this is that these grievances are left unventilated and the aggrieved parties frustrated and even bitter in some cases. The establishment of this division with the active support of the government will certainly address the challenge, and justice has now been brought to the doorstep of our people. This government believes that industrial harmony is crucial to the development of this state. This court, I'm glad to note, is very important in the resolution of industrial disputes that will give us that much needed desired harmony in the state. I need to quickly indicate that government is for now the biggest employer of labor in Bayelsa State. That point should be noted. Although this is the situation, the government is working assiduously to change with a massive investment in infrastructure designed to attract investment and create employment. The current situation is such that we are and will continue to be litigants before the Honorable Court for the resolution of industrial disputes. As I stated earlier, we have an unshakable belief in the independence of the judiciary. We are confident that this court, with its assemblies of judges of impeccable integrity, will certainly administer justice without fear or favor. We as a government are not afraid to be told when we are wrong, and also to be expected to be told when we are right. I assure you that this state government does not interfere with the judicial process and will never do so. We have done all we have done to facilitate the establishment of this division of National Industrial Courts in the overall interest of our people, and not because we tend to gain any undue advantage. I now call on Bayelsans who have genuine grievances, and that is important, that if don't overlabor the court as well. With genuine grievances, to take this opportunity that the event of today have created for us. On behalf of the government and people of Bayelsa State, we should express a profound appreciation to the President of the National Industrial Court of Nigeria and brother judges and sister judges of all efforts and sacrifices made to bring about the establishment of this division. Must also recall and try and appreciate when the President was talking, his emphasis on the need for peace, its emphasis on the human beings here. This will bring the needed peace that unnecessary strikes, actions have been causing, unnecessary down tools have been causing, that as a state, providing security needed, enable the environment for us to develop, because without harmony, the much needed